Good morning, good afternoon, or good evening, depending on where you are joining us from. I'm Jocelyne Cesari. I am the chair of the Religion and International Relations section of the ISA. And in this capacity, it has been my pleasure to lead an ongoing book talk series on religion and international relation, where we try to showcase new scholarship, really tapping not only into the classical literature of international relation but also bringing more interdisciplinary insights. So this is our 11th session, and I'm delighted to welcome you to this book discussion on constitutional intolerance, the fashioning of the other in Europe's constitutional repertoire, authored by Marietta van der Tol. This is a very timely book that offers a very deeply researched examination of how right-wing populist movements across Europe are not only challenging liberal democratic norms, but are doing so by strategically reinterpreting and instrumentalizing their national constitutions. So as scholars or concerned citizens or policymakers, we often think of constitution as foundational texts meant to safeguard rights and define democratic principles. But as this book makes abundantly clear, constitutions can also be subtly or blatantly re-engineered to justify exclusion, discrimination, and majoritarian dominance. And Marietta works documents this trend across several European cases: France, the Netherlands, Hungary, and Poland. And they reveal a pattern, what she calls constitutional intolerance, in which populist movements or governments rather invoke constitutional language to curtail pluralism, limit rights, and reshape national identity. So that is the book we're going to discuss today. And we are very honored to have Marietta van der Tol joining us. She's a Landecker lecturer at the University of Cambridge and a senior postdoctoral researcher at Trinity College. We are also joined by two scholars who will enrich our discussion. Whitney Barth from Emory University, where she is the executive director, and Charlotte McDaniel Scholar at the Center for the Study of Law and Religion. And Luisa Pinto y Nieto from the University of Leiden, who brings a comparative constitutional perspective, and particularly in the Latin American context. So I will give the floor to Marietta, then Whitney, then Luisa for 10 minutes each, and then we will open the floor for your question. Either you can raise your hand or you can also write your question in the Q&A. The session is recorded, so if you have registered, which I think you did if you are here, you will also get a link of the recording, and it will also be posted on the YouTube channel of the ISA Virtual Programming. And I think one member of the virtual programming team will give you the link to the YouTube channel in the chat. So without further ado, I give the floor to Marietta for 10 minutes. Marietta, the floor is yours.
Thank you very much, Jocelyn. It's a real joy to be here and to be in discussion with you all. Good morning, afternoon, or evening to all of you as well. I'm looking forward to hearing from you in the Q&A later on in this session. I brought the book with me, Constitutional Intolerance, because I wanted to start with the story of the book cover, just as a light entry into some of the heavier subjects that I do discuss in the book throughout the chapters. So the picture at the front of the book is that of a storm and a lighthouse. And now that might lead some people to conclude that the book must be about Jehovah's Witnesses, but this is not in fact the case. It is really a book that is trying to say something about, as it were, the storms of our time democratically and constitutionally, and asking the question, where is the anchoring of our social life when we are a bit confused where the direction is, in which direction we're going, but also to give a sense of where some clarity could come from and some guidance could come from in a very practical sense. So the book Constitutional Intolerance is really born from my PhD thesis, which I wrote at the University of Cambridge now before the pandemic, so this feels a while ago. But I've expanded the research from Western European states to Central and Eastern European contexts, and I've specifically chosen Hungary and Poland to showcase in this book, often because people will talk about democratic backsliding in a context of a liberal-leaning states, and this is, of course, a really important topic. But I think what is important is that we're able to find the patterns that can occur in both liberal and in illiberal-leaning states as a way of saying we can't just talk about illiberalism or about liberalism, depending on, you know, which flavor you like or dislike. We need to talk about constitutional systems as such, and in particular, how these constitutional systems are protecting their citizens, or selectively protecting their citizens, or temporarily protecting their citizens. So I think this is really the entry point for me in this book. And of course, there is some deep questions attached to the question of intolerance, namely, you know, who is being tolerant or intolerant? Was the victim, or was on the receiving end of this tolerance or intolerance? And what's the role of power in all of this? Because the Constitution as such doesn't discriminate. It's the people who write particular content in that Constitution with a certain aim, or enforce it in a certain way, or interpret it in a particular way, that make that Constitution come to life in a very particular setting. And it's that particularity that I'm interested in the case studies, while still thinking of those general questions of what is the we, who is the other, and how is power brokered in all of this. So as Jocelyn already said, I try to document some of the impact of the radical right on the development of constitutionalism across these different contexts. And what I've noticed is that there is often a connection to the Constitution. And this is not an accident, because among the radical right, there is often a sense that the Constitution is the heart of national identity, and it expresses what that national identity is. Now, that's already a contested thing, because one group might say that and another group might disagree with that. But I think first we need to understand why that Constitution is so important in the radical right. And then from there we can ask the question, what are the tweaks that we see? How are particular concepts interpreted differently? How is maybe a constitution amended, or not amended, or in some cases entirely rewritten? I think we have to start from sort of that big picture and then look to the particular. So I've articulated 4 forms of constitutional intolerance that I've attached to each of the case studies. So each case study represents one of these forms, and that's really to say, look at the form, not just at the country that I'm writing about, because there is, you know, there is some general reflections that we can abstract from these case studies that we see. So in the case of France, I talk about how laïcité is connected to the language of public order, and how public order as such used to be about concrete safety and security issues that you needed to be able to prove, that you needed to be able to say you're actually targeting in particular legislation. And then you had also to show that what you propose had actually been effective at some point down the road. Now, what we see with public order is that this is increasingly about social norms, and social norms is whatever the majority says it is in Parliament. And that means that this concept becomes really shaky. Now, why does that matter? Public order is a gatekeeper for lots of human rights, not just freedom of religion or freedom of association or other freedoms, but really across the span of human rights, there are many that are attached to public order, some also to public health or to traffic or those sorts of concerns. But the gist is that if we make that gatekeeper what we make it to mean, then what is the protection actually like in case of a majoritarian will to do something about a particular minority? So that's the story I tell about France. In the case of the Netherlands, which is the second case that I discuss, I talk about how this language of public order is also adopted and echoed in the case of the full Vase Bill. Now, again, people might have opinions about whether the Vase Bill is desired or not, but that's not the question that I'm asking. The question that I'm asking is, how is the law used and how is the law impacting on a particular practice, irrespective of what I think of this practice as an individual? So I look at how are arguments for a certain law substantiated. Do they follow the patterns that the Constitution prescribes? And if it doesn't follow that pattern, who is stopping anything? And it turns out that there are perhaps institutions that might be critical of certain proposals, but they might not be in a position to stop it. So again, the question is, who is the actual guardian then of the rule of law? In the case of Hungary, I talk about particular amendments to the Constitution, and one in particular that's associated with the so-called church law. Some people might think of Hungary as a country that really promotes religious freedom, and it does promote the religious freedom of its preferred churches, but it doesn't necessarily promote the freedom of its not so preferred churches. And I'm talking in particular about the Hungarian Evangelical Fellowship, and the way that their legal status was taken away and then partially reinstated, but never fully restored. In the case of Hungary, this happened through a series of laws, but because the laws were not necessarily in line with the Constitution was changed rather than that the law was changed. So that's the third example. The fourth example that I use is that of Poland, where there have been discussions in parts of Poland about how desirable it is to have LGBT visibility locally. Some people might remember that there were the so-called LGBT-free zones. I tend to say those zones didn't really exist. What did exist was certain resolutions that were speaking about LGBT identities and the expression thereof in public space. And what is really interesting about this form of constitutional intolerance is that none of this was in the Constitution. And what happened was that a certain group of legal activists wrote a booklet with a statement on sort of family or marriage, and they attached to that statement a series of explanations of the Constitution that they had no right to articulate. They were just one group of legal activists. They were not the government. They were not a particular minister. They were not a judge. From a sort of constitutional perspective, they were nobody. They did not have the right to do this. But if you invoke this constitutional language as heavy as this group did, what you find is that it becomes normalized to talk about the Constitution in a certain way, irrespective of what is actually written in the Constitution. So that's the fourth example that I've used here in the book. What I would maybe like to close with in this presentation is just a sense of where sort of the direction of this is all going. So one of the points that I make in my conclusion is how the protection of the rule of law becomes increasingly subject to the majoritarian will to actually protect or not protect that. And that means that the Constitution does no longer, in these cases, provide the legal certainty that we say that constitutions afford to citizens. So that's one point. Another point is that our sense of what constitutionalism and democracy mean often tend to get conflated. So people might say, well, if the will of the people is expressed in this particular vote, then surely that's what must be carried out. There's lots of politicians who will speak about the will of the people all the time, but how do we establish what the will of the people is? We've agreed rules about this in the Constitution, and you don't just get to have a vote and say, this is now what the people want, because the Constitution has already preempted the situation in most cases, that sometimes the majority might want things that are against constitutionalism. They might be against fundamental rights or against the protection of legal certainty. They might not follow particular procedures that are prescribed in the Constitution. And this too is a regular feature in the far right to sort of exploit some of the loopholes and try all sorts of procedures to look like you're doing the constitutional thing, while actually undermining the very principles that underlie it. And I talk about this in the context of legal positivism, and the sense that, and this is very technical legal language, that legality and legitimacy become sort of conflated too. So if we bring this down to some essence, one might say that legality means that a law must be based on a certain competence in the law, and that it must flow back at the end to the Constitution. Whereas legitimacy also asks the question, who are the people who are making this decision? Do they have the legitimacy to do this? But there's a second aspect to legitimacy, and that is to say that the laws are made in a way that are in line with these principles of constitutionalism. So legitimacy is much more than 50% plus one. And that's exactly the problem, I think, of constitutional intolerance, that we make this legitimacy about the very fact that you can have a procedure, that you can vote for a law, and that you can then have the law, completely detached from the long history through which constitutions have grown, but also increasingly with disregard for those structures of mutual protection that we offer each other in the constitutional democracy. So I'll finish there. Thank you very much once again. I'm looking forward to the responses and the discussion. Thank you.
Thank you, Marietta. I give the floor to Whitney for 10 minutes. Please, Whitney, the floor is yours.
Wonderful. Thank you so much. And thank you, Marietta, for writing this book. And thank you to the association for having me be a part of this panel. It's an honor to join this conversation. I'll just start by saying that my remarks are on my own accord. They're not to be attributed to my center or to the center that I run, but I'm grateful for the opportunity to reflect on this, this book. And I will say that a lot of this, I'll be speaking mostly from kind of the view from the United States and kind of the context and with which I'm most familiar. There was a lot that resonated with your reflections, Marietta. I really appreciated even your framing in this this initial discussion, the storms of our times, and kind of where are the anchors in our social life. And I think those are really relevant, both relevant framing and also relevant question for the current day. I think, you know, the book really highlights what you call the administrative nature of intolerance, you know, these kind of highlighting things like economic benefits, public peace and order, notions of the common good, even loyalty. And, you know, a few of the, and we talked a little bit on your presentation about public order. I think I would, you know, is thinking about how those terms might be used here in this context, thinking about national security, executive power over foreign affairs, thinking about ways in which bias has been kind of framed in ways of you know, both historically and at present for highlighting the different ways in which the Constitution may be used to keep people out or keep people in to certain groups. And I think, you know, and one of the challenges I think is that, you know, many of these things are, you know, important, legitimate concerns in their own right, you know, national security, combating bias in various ways. But then the clash becomes when these things are kind of pitted against the suspension of constitutional norms like due process, right? And so this is something that we're, you know, the kind of storms of our time, what this is looking like, I think in the present. And also separation of powers. I mean, that comes in a lot too, as we think about, you know, in the United States, we have a threefold system: executive, legislative, and judicial. And so when one branch, you know, in the name of pursuing one of these aims, you know, starts to become or try to usurp perhaps the legitimate aims of another branch, how does that, you know, what does that look like, and what are the backstops for that, and how does the Constitution, you know, the Constitution gets pushed and pulled in different ways, and that got me thinking a lot about the malleability. You started off your presentation as well, talking about constitutions as kind of a you know, this kind of, you know, not static, but sort of stable, an assumption of a kind of stability, that this is constitutional law. This is the bedrock of our whole system. And I think there's truth to that, but there's also a malleability to that, especially as different legal arguments are made and whether or not they're accepted, or, you know, the Constitution becomes malleable in different ways as we're open to interpretation. And I think, you know, it becomes almost this this push and pull, this back and forth. And so the word, as I keep saying, it's come to my mind is this: in what ways that the constitutions become malleable in this moment, or not just this moment, but historically certainly as well. And thinking about and that also got me thinking about the idea of constitutional intolerance, and then the tying of that to intolerance in society more broadly, and the ways in which different conceptions, your book highlights, I think, very well how there's the constitutions provide this kind of legal framework, but they're also normative and imaginative framework too. That we have this set of beliefs, we have these sets of commitments, we, the nation, and I think that the idea of whether it's freedom of religion, whether it's freedom of speech, whether all these ideas about what the Constitution means for us and who we are, I think is a really salient part of a conversation right now, and in terms of what how does constitutional intolerance, how does that bleed into society, how does societal intolerance bleed into the Constitution, this kind of back and forth that I think you highlight well in these different contexts that you've investigated. It's interesting too to think about. You talk about toleration along as entailing a spectrum of practices of coexistence, and I think that was also really kind of a useful framing, and it got me thinking about, well, what is that spectrum of practices in our own context? Certainly, sometimes those practices, toleration looks like we've had a long history of the idea of, well, we'll tolerate you, but over here, right? Whether it's a racial minority or religious minority or gender minorities here, but not allowed to be fully integrated into broader society. You think about different ways in which housing, racially discriminatory housing in the United States, and even in public services over time, and even religiously, when we think about the ways in which different religious groups, especially as different religious groups came on the scene in various points in our history and became more mainstream, thinking about the challenges those different groups, whether it's building mosques or getting clearances for parking lots for temples, there's always this kind of friction that we see in various ways, and there has been legislation that's been passed by Congress, like in things like the Religious Freedom Restoration Act, but also the Religious Land Use and Institutionalized Persons Act here in the United States. It meant to get at some of that bias on the ground in these local places. And so, there are ways in which the law steps in, and then there's the ways in which the law can be used in ways that are that you say kind of continue to keep people out. And I also, you also highlight how these different multiple practices of toleration and dissimulation shape the experience of real people. That's a quote. And I thought that was really telling too, because I think that gets at the kind of, we're talking in these big theoretical terms about the law, the Constitution, but these are individual people's lives. And when you get to things like these kind of bans on religious clothing, for instance, like these are individual people who are making, have to make decisions about how to be in the world, whether, in accordance with their faith or in contravening of the law or, or otherwise. And I thought that's also raises interesting questions, I think, also about generational differences. I know, like in the United States, the experience of immigrants versus the children of immigrants, and sort of how different generational expectations come into play with senses of belonging, and even what the idea of America and what America means, and has America as a concept, as an idea fulfilled its promise. And I think we're continuing to seeing some of that. It's an ongoing conversations in that space as well. I loved how you pulled in the historical as well as the contemporary examples, and you know, you talk about Westphalia and the idea of the unum corpus, the idea of the possibility of multiple and existing corpora, and it brought to mind here in the United States we highlight the e pluribus unum, out of many one, and this idea that we are somehow one even in the midst of this deep diversity. That also, you know, kind of got me thinking about what kinds of pressures does that put on on the Constitution to be this, you know, to kind of or in what ways is that shaped by you know, the constitutional interpretation that may, you know, whether explicitly or implicitly favor some groups over others. And you know, I think here in the United States, we'll be speaking specifically about religion. I mean, our court, the Supreme Court at least, has been fairly favorable to religious claims in recent decades, especially, you know, in a number of different ways. And so that also raises a whole nother set of questions in which, you know, when religion is, and you talk about this in a couple of other your case studies about when religion is kind of goes head to head with other religious groups go head to head with other groups that, you know, other groups that have their own sets of rights, you know, this LGBT groups or otherwise. I think that remains to be, I think will continue to be a source of tension for here in our context. You know, and we have an executive right now that seems to be very favorable towards looking for the ways in which at least Christians have, you know, been the source of bias, you know, experienced bias within governmental services or governmental organizations. And so it kind of remains to be seen how some of these tensions play out. And I think that's also the point of your book. This is a continuum. These are ongoing storms in different ways that will find you know, different manifestations as we go along. But those are a few of my thoughts. I am happy to cede my time as well, so we can get right into the discussion after Louise's presentation. But I just want to say thank you again for the opportunity to reflect on this book, to have this conversation with you all. It's really a privilege.
Thank you, Whitney. Luisa, the floor is yours for 10 minutes.
Now, good afternoon, everyone. Thank you very much for the invitation to be part of this discussion. It's a real pleasure to be here and discuss this timely work of Marietta, Constitutional Intolerance. I think this book is really a necessary book. I think it offers like a pioneering theoretically ambitious perspective on what I believe is one of the defining challenges of our time. I would say the erosion of constitutionalism or of constitutional democracies from within. And I remember watching Marietta presenting the theme before the book was ready. And I think it's unique because of many aspects. I think there is a deep personal investment, and there is a lot of intellectual curiosity and creativity in the book, because she, for me, being someone that studies constitutional law, the starting point of the discussion is very interesting. I think she seeks the roots of intolerance, which I see nowadays deeply intertwined with polarization and democratic backsliding, beyond what we would think of being a democratic or a political problem. She goes to the roots of our models of modern state, our idea of constitution, our idea of democratic constitutionalism, and even what for me is important in what I teach, our theories and our conceptions of rights. I would really say it's a necessary book for every person interested in constitutional law, because there are lots of very important points, private and public, the idea of rights, the idea of democracy, the idea of what the Constitution settles, what can we change democratically. So I think it's a must read for everyone. I just want to highlight some points and make some questions so that we can get to the discussion. What I think is very compelling is, as I said, its innovative character, and I think Marietta has a sound theoretical basis for her claims. She brings comparative historical perspectives to make like this critical journey. And I think it's it's a huge work comparing France, the Netherlands, Hungary, and Poland. And for me, it was very important that she tries to deconstruct the myths underpinning our modern constitutional orders. I think this is very important to try and understand what's happening now, but also to think constitutional law from a more critical perspective. I think there is a thesis on the heart of the book that constitutional intolerance is not an anomaly, not a deviation exclusive to the so-called illiberal regimes. I think there is a structural risk inherent in constitutional orders themselves, particularly when they fail to protect diverse identities and reproduce dominant ideologies under the guise of neutrality, order, or even the national identity. I think there are two very important aspects in the book that make it essential for understanding the challenges of constitutional law and practice nowadays: the narrative of tolerations and the mechanics of intolerance. I think one of the most remarkable contributions is the reassessment of toleration. I think we are often told that modern constitutions represent enlightenment's triumph of moral clarity, tolerance, liberty, rights, equality. But the book asks us to pause and reflect if it's really true. Drawing from early modern history, Marieta shows us that toleration has rarely been a purely moral or philosophical ideal. It had often a pragmatic administrative compromise rooted in concerns about public peace and economic benefit. And I think this is very important to the debates we have nowadays. I think this insight, this stabilizes the myth of Westphalia, and it reveals that the historical roots of tolerance are fragile and conditional, which in turn helps us to make sense of the constitutional intolerance we are witnessing today. I would not say a lot about the mechanics of intolerance because Marieta talked about them in her presentations. She identifies, and I think it's really important to understand what's happening nowadays, the three forms: the dynamic reinterpretation, the ad hoc application of vague constitutional concepts, the manipulation of constitutional amendments, and finally the pseudo-constitutional measures. And I think the four cases she studies show how these mechanisms can be implemented and how dangerous they can be. I think it's also a Herculean work to compare these countries. And I know Marieta is also learning and speaking Hungarian in order to assess original material. So I think this is important to recognize what an effort lays behind this research work. And I think for me, thinking of the contribution of the book, it makes me ask some foundational questions for constitutional law. What is really a constitution, not only legally speaking, as the higher norm in a country, but also politically and socially? And I think this leads us to a lot of food for thought, because, for example, the idea that populists and right wings are using the constitution leads us to the questions how to address these problems. And I also think this is very important if we see what's happening in the Netherlands now. I'm from Brazil, and I always think it's interesting to compare Brazil and the Netherlands. In Brazil, the constitution is now a very important legal document, but also very important socially. And when I look to the Netherlands, I think there is this tradition to say that they have a sober constitution. They are not relying so much on the constitution. There is no constitutional review, no constitutional court. Sometimes the phenomena are quite, they resonate with each other. So I think we have to rethink what is a constitution and how the constitution is being used in our practices. I think the book also makes us question what is constitutionalism as an Western export. Is it really capable of all these promises of protecting liberty and equality? And I think that the idea of having a constitutional identity is really linked to the idea of a constitution, but we should also think what is a constitutional identity. especially if it becomes a vehicle for exclusion rather than inclusion. I think Marieta makes it clear that constitutional identity has always been built on the distinction between belonging and othering, between the promise of liberty and the practice of selective inclusion. And I think there are some contexts when this is very clear and some others that this is very disguised. So the book calls our attention to delve deep into this. But for me, reading the lessons in Marieta's book was did not really leave me in despair. I think she challenged us to imagine a different constitutional future, one that would be rooted not in empty proceduralism or neutrality, but built upon a substantive commitment to democracy, where public space is truly shared, where differences are not erased but negotiated, where constitutionalism is not a mask for power, but a living framework for pluralism. I think Marieta's constitutional intolerance, more than making us think about our assumptions and more than being a necessary diagnosis, calls us to reimagine the constitutional project itself. I think she's inviting us to confront the uncomfortable truths about the legal and political systems we are living in, and to commit both intellectually and politically to the hard work of building democratic societies where diversity is not a threat, but a foundation. I would really like to hear Marieta talking about a lot of questions that come to my mind. How can we citizens engage in this idea of trying to construct another model of constitution and constitutionalism, especially when we see that it is operating under the veneer of legality and democratic norms, but sometimes it's just a disguise. Working with constitutional law, I'm also very much interested in this idea of interpretation. What would be the legitimate interpretation? Who would say the last word on interpretation? Because we see populists using a constitution in new interpretations, but sometimes it's also important, for example, when we look into constitutional rights, especially judicial interpretation was very important for developing rights, social rights, and a lot of rights we are very found nowadays. So this would be a question. And I also wanted to finally ask Marieta if she thinks that these dynamics of exclusion, whether based on religion, sexuality, ethnicity, truly are about identity, or do you think that in the core, they disguise deeper economic and structural interests? In other words, is identity politics being instrumentalized to protect existing power and resource distributions, or is it really about identity? Now, thank you very much. I'm looking very much forward to listening to you.
Thank you, Luisa. Before I give back the floor for a few minutes to Marieta, I would like to add a few points, actually following the path that Luisa just opened, just to say that I really salute the project here, because I am not a lawyer. I'm a political scientist with a focus on religion, and I look at the building of nation states outside the West. So I first experience the fact that the modern state is not democratic and tolerant. So it was very important to do this job, because when you are in the West, we tend to think that indeed the modern state is the paragon of toleration, which is not the case. And I see the consequences of that. The building of states in Muslim majority country led to the opposite of toleration. So there is something in there that was important also to debunk in the history of the West. And that the fact that the state and democracies are not synonymous. It sounds obvious, but sometimes you read some literature and you see the slippery slippery slope that, you know, state and democracy have some kind of affinities. They do not. And most of the states, including outside the West, have been built in an authoritarian way, okay? So on the principle of equality of membership, okay, and sovereignty of people. The thing I would like to push back on is the kind of drastic separation you do between the Westphalian order and the current state. This is something that I would like to discuss more with you, because actually most of the theory or literature challenge this idea. And you have to take it from historical and genealogical perspective here, not only from the history of the law, but the history of the different expectation of people. And here I'm relying on the work of someone like Charles Taylor. You have a much more nuanced approach here. Toleration is not the opposite or the distinction of modern liberal pluralism. And I'm thinking also of the work of Connolly, of others. There is no break here. That's what I want to say here. Of course, the Westphalian toleration was hierarchical, 100%. I agree with that. But nonetheless, it's a critical juncture, as we say in my jargon of historian and political science, because it introduced a conceptual break that didn't exist before, which is to move away. And it didn't happen overnight, agree, from religious uniformity and enabling some future forms of mutual recognition. Does it work? Is it perfect? You're right, it doesn't. But it is not a complete break from the past. It is a transition, because there is no before and after, ever, never. But I think it's important here to be aware of the historical development and not the contradiction between the Westphalian order and the modern nation state. And this is also going hand in hand with your discussion on sovereignty. It's not either or. It's not going from divine right principle rule to people power. Actually, historically, if I look even at the country you take as one example, it was one step forward, like France, one step forward, two steps backwards, one step forward, two steps backwards. It is not this kind of break or overnight change. And here there is Canton, Skinner, Pocock work that would nuance this. So I'm not going to be longer on that, but I would say instead of claiming incompatibility here, I would rather think of theoretical dialectical transformation from hierarchical toleration to egalitarian recognition. And we are still in the middle of it. As Whitney said, there is always a new front in terms of sexual minority or the group that need this recognition. And from princely to popular sovereignty. I think it's not either or. Again, it's transformation not achieved, not always successful, but always going on. I would stop here, but that's to give you a little more things to respond to. Okay, that's if you want to, Marietta, you don't have to respond. Okay.
But I'd be happy to. Just briefly, it's impossible to do justice, of course, to all the reflections that you've shared, and thank you for being so generous with your time reading the book, but also reflecting on it and articulating your own thoughts. I really appreciate that. I think where I would like to pick up first is precisely this sort of what happens at this sort of these junctions where we see the transition into the modern state, because I think I completely agree with you, Jocelyn. This is a historical process. It's not an event. And I think that's one of the things that I like to point out on a historical level, while I'm also holding that together with the imaginative shifts that people have been articulating for a long time about what this moment in the modern state was. And I think there is some really deep disciplinary differences here And I think in my own book, I'm possibly commenting particularly on the reading that is popular among constitutional lawyers, which is, you know, if you read your average constitutional law book on this period, it might even say just in a couple of sentences, in a couple of strokes, we had a modern state, the will of the people was now what matters. We have a constitution, the constitution affords rights, and the problems of our religious wars are solved. Constitutional law is not very good at engaging this question of transition. And I think you're quite right in pointing out from within other disciplines that actually the story is more complicated. So I think I want to say I actually agree on a deeper level with some of these observations that you make. But I think there's also positionality here that is specifically engaging with how constitutional lawyers have told this story. And I think it's really important to bring these different perspectives together. I've often wrestled with that myself as well, because the way that history is told is not always the way history was. When you go back to the primary sources, there's often a much more muddy picture than sort of the meta stories that we tell about this development or transition. Another one is, for example, how, you know, some people tell the story of religious liberty coming out of the Constitution. In some cases, they say it might trace back to practices of toleration. Maybe it traces back to her understanding of epistemology, etc., etc. We can tell many stories about it, but from an administrative, constitutional or legal perspective, there are certain moments that matter more than others. And those are the moments where constitutions are written, are revised, are amended, etc., etc. And I think I'd like to, again, affirm like what you were saying about one step forward, two steps back. I think, again, it's a disruption, hopefully, of these sort of linear stories of progress that have been really important within the discipline of constitutional law. Now, that's enough, I think, about sort of that disciplinary angle. I think what I would like to pick up is something that Whitney said before, which is about the social imagination, really. How are people not just having a constitution, but what is the sort of social and imaginative role of that constitution in society? And I think this is really deeply tied to particular histories of each of these countries. It's very hard to tell one story of what this is or even what this should be. But I think if I were to try and articulate a common thread, it would be the sort of recognition that you need some way of brokering power when communities are so divided that they don't know how to move forward together. And that's something that comes at the back of some of these religious wars, that people have tried everything, even tried erasing the other, figured out that they couldn't, and then realized that actually maybe something else is needed to lay down in the law, perhaps what people's rights or privileges were rather at the time, because this is not really the language of rights as human rights, but certain rights as you're entitled to a thing based on an agreement. And I think this recognition that you need this sort of sense of not just an agreement, but also a sense of this is what shapes our common life. I think that's really important to sort of try and imagine what that is like, to go through that sort of moment of change, and the sort of legal certainty that you might get or you might not get, or maybe it was written down in an agreement, but the agreement wasn't enforced. You know, there are so many ways in which the story is kind of, you know, is a mixed bag. But I think still the idea that the Constitution emerges as this sort of social identity is really not where things started when nations were being built. Like, constitutions were written by elites, lots of working class people. That's before you talk about women or previously enslaved people, were not able to participate in that process, were not able to vote in that process. So what we have as a sort of legacy of that 19th and 20th century is a constitution that has become more and more important, but after the fact. And then you can maybe tweak things a little bit. You can amend it, or you can say, well, maybe, you know, constitution is not quite up to date, you know, 30 years at least behind social reality. That's all true. But I think there is, in the social imagination also, there can be a gap between sort of what the constitution is and what people believe it is. Or it can be like in America, where everyone says, you know, the Constitution is really important, and maybe they know a few amendments, but if you ask them sort of what's the overall shape of the Constitution, maybe not so easy to answer. There was a quiz that I once did for some Dutch youth at a summer camp, and I asked them all to recite the first article of the Dutch Constitution, just to see how far they would get. And it was really interesting because I remember it's a couple of years ago now, but some said the Dutch state is an independent republic, and I was like, oh dear. That's really not what is in the first article. It's an equality clause, and that, you know, people have to be treated equally on the basis of all sorts of grounds, whatever. But these you've had no idea what was in the Constitution. So what is the social imagination? I think this comes back to the question of what people think the Constitution is doing for them. And what the Constitution was doing for them in a historical sense is actually changing the way that communities that didn't know how to live together, how they would relate. And I think our generation has come to take for granted some of these ways of coexisting that actually, you know, we don't really understand what difference it makes until it's taken away from you. And I think that's something that we see increasingly in the states that I discuss, but also Whitney is quite right of pointing to the case of America, that sort of protective status that is ascribed to the Constitution is in fact socially selective and really, you know, something that not all people see as a protector, but as a threat. So I think that is just one way of picking up at some of the things that Whitney has said. I want to say briefly something about Louisa's points, and thank you again for reflecting from that comparative angle, sort of, you know, the things that come up, but also the way that you formulated the issue of neutrality together with public order, together with national identity, because that's something that I've hoped that people would take from the book, that this is not a question of whether you like or dislike the right or the left, but that this is a question of what are these mechanisms through which intolerance is brokered. And I think you also come back to this question of what is the Constitution politically and socially and not just legally, and how do we enthuse younger people for this project of constitutionalism? I think there is no obvious answer to that. That's probably maybe an honest way to start, but I would still say, as I said earlier, when you have rights taken away from you, I think people will come to appreciate why it matters. And I think, especially in America in the current moment, there's a lot of young people who are looking to the Constitution and to judges to protect them when actually the government is doing things that are contrary to that Constitution. So I think that is, in a way, reviving almost the importance of what that Constitution as a social institution and a legal institution is, and what it can do for you. I think at the same time, we need to understand that for younger people, what their problems are going to be, that they need the Constitution to broker, are going to be different. And I'm thinking of the way that technology is impacting on their social life, for example, and just the glaring absence of any of this from constitutions. Like, it's maybe interpreted by a judge into some sort of old technological thing that nobody knows existed, like the telegram, for example, but the real ones, not just the one on your phone. I think that's a real challenge, and how technology is changing social fabric, but also the ways in which we think we inform our opinion, and the ways in which we then think our opinion will shape our politics, when we see that our politics and our opinion and our lives are increasingly shaped by how we relate to these technologies. So I think that's just one example of, you know, we are in constitutional law often treating the Constitution as museum studies, but we need to look to the future and think, what are the challenges that are coming our way? And I think the current moment of polarization shows that actually the relevance of that Constitution might in some times be more obvious than in other times, but the fact that it is there is what secures us in this moment, and hopefully also what will secure people in the future. And I just really want to encourage people to think of the Constitution through that longer durée, the longer lens, and the historical lens, but also just to see that this is not just about the fights that people have in court today about one issue or another issue, important as they are, and, you know, important as they are to our social identity. At the end of the day, that's not all that constitutions do. Constitutions do also just make people responsible for certain social functions. If you took it away, who is going to collect your bins? Who is going to make sure that the sewerage is working? Like, these are very basic things that might, it's not a theoretical thing to say it might get threatened if your local authority derives this from some delegated power or something, or if a certain matter is left to a local issue or to a local authority, or is particularly withdrawn from local authority. These things matter, but to just everyday life. So I just want to highlight that, as it's not just about the big culture war issues, it's also just about the practical things that we've all learned to take for granted, like drinking water from your tap. And that's maybe just a reminder for us of how fundamental this is to our social life, even if we don't see it or recognize it or even value it.
Thank you very much. We have a few minutes left. If someone in our audience want to ask a question, make a comment. I don't see any question here. Yes, there is a question. Thank you for this insightful discussion. I'd like to ask a question regarding the broader implication of constitutional interpretation. Some of the cases show how populist movements reinterpret constitution to justify controversial decisions. If constitution can be reframed as tools of political power, could the same apply to foreign policy? Could the EU or its member states also reshape foreign policy, not just as a reflection of values, but as a strategic tool driven by internal ideological shifts? I have a response, but I want Marietta to say. What do you say, Marietta?
I think, first of all, like, foreign policy is a very different animal to constitutions, and that's not an op-out, to a cop-out to not answer that question. I think I would want to say that in foreign policy, there is also certain doctrines by which people think they order their responses to events in the global context. And these doctrines for a long time were sort of attached to either theoretical sort of constructs or to pragmatic needs of a particular society. And I think what is really interesting to see is that these radical right movements are approaching diplomacy completely differently. I think we've seen that in the last couple of months. I think one of the things that made me smile today was how GD Vance are sort of saying, if Russia and Ukraine are not making a move, we're gonna leave this whole thing. I mean, if you understand anything of diplomacy, you know that a timeline of 3 months is not a very realistic timeline. These things take shape over a longer period of time, and with careful crafting of messaging to other countries, giving incentives, removing incentives. And it's really interesting to see how the sort of long-term vision, especially in the American context, seems to be disrupted in the current moment. And some people might say, oh, it's just, the talking points of Putin repeated, and certainly we do hear some of those repeated. But at the same time, there is also a disorientation, I think, within current American foreign policy as to what its role is in the world. If the highest sort of order of your love in the, words of GD Vance, is your nation, and then what is beyond that? Are you even responsible? Do you have a vocation there, yes or no, and at what sort of cost? Now, this reflects also in the European Union, because one of the things that we've seen here is that the sort of question of, do you align to America or do you need to be more independent, is also one that has become more fraught, not just in the current moment, but even over the last 10 years. You could see radical right movements challenge the position of Ukraine vis-a-vis the European Union. Some even organized referenda to sort of say, against this association treaty between Ukraine and the European Union, to kind of say, no, this shouldn't be the case because, Ukraine isn't really all that European, for example. These were obviously also talking points of the Kremlin, but they also reveal a deeper sort of sense of what Europe is and what Europe is meant to be on the global stage. And there is not a clear agreement within EU member states, let alone within the institution of the European Union as such. So I think, you know, it's hard to sort of transpose all this entire book, of course, to foreign policy. But I think some of the things that I see in common are these. It is a sense that one must be independent and self-sufficient. That begins at a sort of individual level and the idea of masculinity, but it also comes back at the constitutional level where, you know, if you are the ones who are strong, you get to say what the law is. And it also sounds now in international relations that if you're strong, you get to say what your reality will be. And if you're not strong, if you cannot defend yourself, well, why should we protect you? It's not so different from, well, you're a minority, too bad for you. Why should the Constitution protect you? Or on an individual level, if you're unable to work for whatever reason, you know, who should be paying for your social security? So there is an underlying understanding of I think what a human is, but also what a constitution and a nation is, and what, you know, what the global order should or shouldn't look like. And I think we should pay attention to those sort of coherences between these different levels, micro, meso, and macro. Not to say this is a unified theory of the world and it's a sort of theory of everything, because it's not theoretically deep, but it is a fundamental posture that sort of throws out some of the other considerations that have been carefully built up, both in the context of constitutionalism and in that of foreign policy. So that's how I would approach that question. Thank you.
Thank you very much, Marietta. Thank you, Whitney. Thank you, Louisa. And for our audience, I just want to remind you, you can read in the chat some information on the virtual programming of ISA with some links. And also we have an upcoming book talk on pluralism, Islamism, liberalism, and nationalism in Turkey. So not very far from our discussion of today, coming up on May 8th. So stay tuned and join the ISA virtual programming for more information. Thank you very much to all, and see you all soon in different capacities. Bye-bye. Bye.
Bye. Thank you again, Jocelyn, for hosting.
Welcome. Bye-bye.